and hand the presentation over to Brian. Brian, good morning.
Good morning, David, and good morning all attendees or participants. Yes.
Thank you very much again for agreeing to run this series for us. The one we ran at the beginning of last year was incredibly well received, and I know today's session will be of extreme relevance to everybody, everybody in the audience, particularly in light of some recent cases that occurred locally around trust, because there seems to be some question mark as to the continued relevance of trusts given the outcome of this case, and I think you're going to provide some clarification on that. So we look forward to what you've got to say, and look forward to the various cases or the various examples that you're able to share with us as we go through the session. Brian, thank you.
Thanks very much, David. And yeah, and the case in particular that David was referring to, and I'll go into it in a bit of detail. And from a trust perspective, it is somewhat, well, it's given a lot of attention, and there are a lot of trustees and the trust industry itself, and I know from our company's perspective it will have major impacts and implications, and that is the Clayton case. And as I say, I'll deal with that in a bit of detail later on in the presentation. But what I thought from today's perspective, yes, there is a lot of rhetoric, there is a lot of talk, there is to be honest, people on both sides of the fence as to whether trusts are still relevant, are appropriate, or with due respect, whether they're a waste of time or waste of money. So from an overall perspective, I thought I'd just have a look at the rationale or the reasons behind the trusts, the benefits of a trust, and the cost, both monetarily and psychological, to make sure that when a decision is being made for the establishment or in fact for the winding up of a trust, that it is being made for the right reasons. So if we look at the essence of a trust, what is it all about? What is the basis of a trust? It is an arrangement between three parties, being the settlor, the trustee, and the beneficiary. So the settlor, that is the individual or individuals as the case may be, who wish for whatever reason to establish a trust. They want to protect assets or ensure the certainty of the passing of assets, and they have that reason for the establishment. They then hand over, and this is often the most issue or the most difficult rationale to come for those individuals, is that transfer of ownership, that loss of control, that loss of ability to direct, to instruct, or to do with those assets as they see fit, because the trustee has the complete ownership, control, and destiny of those assets, and they are charged with that responsibility to manage, to look after those assets for that third party being the beneficiaries. So the trust deed itself, for want of a simpler term, that's the rules. That's what the trustees can do, what they can't do, and it binds the parties together. It's, as it says there, the operating manual for the trustees. So those roles, as you can see there, the settlor, the individual or individuals that establish the trust, the trustees, they become the legal owner. And one of the most common faults in trusts and trust administration is the assets not being transferred and registered or recorded in the name of the trustees. So it's all very well for the individual to say, yes, we'll set up a trust, we'll transfer our house, our investments, even the life insurance, for example. There needs to be that clear change of legal ownership from that individual's name into the trustee's name. And then we have the beneficiaries. They are the individuals or organisations who are entitled or who have the right to the benefit of those assets. And it's interesting, looking forward with the proposed change, because at present the trusts and trust administration are governed under the Trustee Act. The proposal as submitted by the Law Commission and currently under review and back before Parliament is for the Trustee Act to be replaced with a new act called the Trust Act, and this will give beneficiaries greater rights, greater entitlements, more accountability as far as what is happening and what those assets that are being held for them, how they're being used. At present, and it's not uncommon that a lot of beneficiaries are kept in the dark and aren't aware either of the establishment or the assets that are in a trust.
A couple of quick questions, Brian, before on that particular slide. Number one, you mentioned a new act. When is that likely to be enacted?
It's the initial review by the Law Commission was about 3 years ago. It's back before the Select Committee, so we're anticipating within 12 to 24 months that there'll be a new piece of legislation to replace the old Trustee Act. Yes.
Right. Okay. And are there any specifics available yet, or is it still sort of relatively?
Yeah, there was effectively the Law Commission report, which was about a 400-page document, is being the actual draft bill itself hasn't been prepared yet, but the intent, if you like, or the summary of the Law Commission's report is effectively going to form the basis of the new legislation. Yes.
Oh, right. Okay.
So. And what that is effectively saying is that, hey, the old Act is out of date. There needs to be greater accountability, responsibility and liability on trustees. There's greater power for beneficiaries to seek this information. They will be entitled to more details. It's, I suppose, bringing it into the 21st or 22nd century and avoiding the old fog or smog that used to, or perhaps even still does, surround trusts, and that it's my trust, I'll do what I like with it, I won't tell anybody, if it's on a need-to-know basis, and you don't need to know, even though you may be a beneficiary, for example. Yes.
I understand. Okay, that's cool. The second question was the settler. You mentioned it has to be an individual or individuals. Can it be a corporate?
No, it would need to be an individual. Often, for example, you could have, and it's quite common for charitable trusts as well in that, where there's a group or an organisation that wants to set up a trust. There would normally be an individual as the settlor, and then from a trustee's perspective, that could be a company or a group or organisation or professional trustee, obviously, yes.
Right. So if there was you mentioned the idea of a charitable trust. If there was an organisation that wanted to set up a charitable trust, then perhaps a director of that organisation would need to be the settlor.
Or one of the members of the organisation, for example, if you had SPCA, for example, they have got a number of trusts, but if there was another subgroup of SPCA that wanted to set up a charitable trust for the intention of protecting all the cats before Gareth Morgan gets a hold of them, for argument's sake, then one individual could be the settlor, and then the trust would be then set up with the trustees. Yes.
Fantastic. Brilliant. Thank you, Brian.
Okay, so coming back to the excuse me, the crux of why have a trust, the relevance of a trust. It's, in my simplistic world, I would suggest two main reasons are the predator or creditor protection. So when we talk about predators, that's the relationship, the new partnership, or even, and we're seeing a lot of this at the moment, parents concerned about their children and the choice of the children's partners. So rather than when the parents pass away and leave the money to the son, which could potentially then go into his relationship and become relationship property, and if that relationship was to end, result in a loss of 50% of that inheritance, then parents are looking at the setting up of inheritance trusts. So where there's the potential for issue through relationships, then that is a red flag or trigger, if you like, to consider the establishment of trusts. We also look at it from children and grandchildren. If there's a child who has special circumstances, be it education, medical, or other reasons, then it's appropriate for funds to be set aside in a separate trust. And often, and we're seeing the re-emergence of a lot of life insurance trusts where parents or people who have a particular reason, then they may have a policy and they want that policy, excuse me, or the proceeds of that policy to be used for that reason. Then once the policy has been issued, it could be then transferred into a separate trust with the intent and purpose that it be used for that specific child, grandchild, or individual. And then we have the creditor situation, or the protection of the personal assets from the business risk, the business liability. From an estate planning point of view, where there are specific wishes or directions, then a trust can be the vehicle to achieve that. I'll talk shortly about challenges to wills. A trust in itself cannot be challenged unless it is set up deliberately to avoid a potential claim from a creditor or relationship that is known at the time of the establishment of that trust. So for example, if you have a particular reason to set up the trust now on the basis that any future events that you may come across, you want those covered, then that's fine. Whereas if you have a relationship now and you are deliberately trying to protect or stop those assets from being split in the event of the breakup of that relationship, and you're in that relationship, then no, there would be opportunity through the courts for that trust to be challenged. So at the end of the day, sorry, David, was that?
No, I was about to ask a question. I was going to let you finish. But what I was thinking of was you mentioned the rights to challenge a trust, and I was thinking of the Bridge Corp situation
Yes.
not long ago, where I think I can't remember the name of the director, but he was he put his Porsche and something else into a trust, and
is it not Ankovic? Something Vich or something, isn't it?
yes, that's right.
Yes.
Yeah.
Or the other classic example, and unfortunately I'm old enough to know it, is the Equity Corp and Alan Hawkins scenario. Back in, and you might correct me if I'm wrong, David, I think it was the late 80s when Equity Corp was flying high. Unfortunately, it crashed along with a lot of investors' funds. The BNZ took action against Equity Corp and Alan Hawkins for funds that he owed or that Equity Corp owed. However, Alan Hawkins had the family farm and other assets in a trust. That trust was established well and truly before there was any blip on the radar as far as creditors or any awareness that the issues facing Equity Corp were coming. The BNZ were unsuccessful in challenging the trust. And the reason that they were unsuccessful was that the trust, when it was established, there was no awareness or no a way to know that the future that did happen was going to happen, and therefore it was held, the trust was set up for legitimate reasons, and there was no ability to overturn or to challenge that trust and to get back the assets from the trust into the individual's name and then be available for the BNZ or other creditors in that. Yes.
Yes, thank you. And I've got a couple of people, Linda and John have mentioned, it's Patricevic. You're right, Rod Patricevic was the Bridge Corp director.
Right.
Thanks, guys.
Thanks very much. The other, from an estate planning point of view, and again, this is something that we're doing a lot of at the moment, if there is a potential inheritance coming your way or the way of a client, for example, rather than those funds being left to the individual and therefore going into their hands and potentially becoming available to creditors or any other predators that may be on the scene, have the person who is leaving the funds pay it to a trust, or to a trust that they may in fact set up themselves, so that the money does not go into the individual's name but goes straight into the trust. So the classic situation is mum wants to leave the funds to the children don't want to receive the money because of their circumstances. Either mum sets up the trust for the children, or the children set up a separate trust, not having it going into their existing family trust, which could include their spouse. So it's a separate trust which is purely for that child and his or her children, and no spouse of that child is included in that trust. That way it's completely clean and ring-fenced, and it will pass down for that son and or sibling heirs that he or she may have.
Would that be done typically on a testamentary basis, Brian, or would that be done during the lifetime?
We would normally recommend that the client set it up, and the trust either be set up by the client themselves or by their sibling, for example, if it's a sibling that they want to protect. So, and that is set up during the will maker's lifetime, so that their will would then be reviewed and reflect the provision for that trust as the beneficiary, not the individual. So under the terms of the will, the beneficiary of the will be the Joe Bloggs family trust, not Joe Bloggs the individual.
Right. And what would be the reason for doing it during the lifetime as opposed to as a testamentary trust?
Well, with a testamentary trust, that's a trust that's created pursuant to the will. So generally speaking, a inter vivos, or a trust that you create during your lifetime, is more flexible, has greater ability to be varied or to change or to meet circumstances, whereas a will that you create whereas a trust that you create under your will would only come into effect in the event of your death, and is more restricted and doesn't have as wide a power and ability to be more functional than what an inter vivos trust that is separate, that is created during your lifetime, would have.
Right. Okay. Thank you.
And the next point about the reasons for establishing trust, obviously from an income planning point of view, yes, there's the ability to split income if it's earned by a trust. And going back to my initial point about beneficiaries, the rights of the beneficiaries at the present time, the only rights that they have are the rights to be considered for income distribution, for example. So if you've got a trust that's got an investment portfolio that's got $100,000 income to be paid, or is able to be paid, that can be apportioned at the trustee's discretion to one or all of the beneficiaries. So there can be if you like, discriminatory decision made to favour one beneficiary over the other beneficiaries, and those other beneficiaries, the only rights that they have is the right to be considered initially, and then for the trustees to look at all the beneficiaries and say, right, based on the information that we have, based on the circumstances of the beneficiaries, it's appropriate to allocate all of the income to one person, for example. And that's appropriate. And that, from a tax point of view, can also be efficient as well, in that income could all be allocated to one beneficiary who's at a lower tax rate. The trust has paid tax at 33, that beneficiary is on a 12% tax rate, then potentially there's a tax saving there of 21%. So there are tax advantages through trust and income splitting. So if we go, sorry David, is that?
No, go ahead, Brian.
Yep, okay. So if we come back to the reasons for the establishment of a trust, yes, it's about protection of assets for future relationships, and I often say it's control from the grave, whereby what you're saying is that for your children, for example, you are protecting them from themselves, so that through the use of a trust, the asset does not vest or become the ownership of that individual child. It sits into the hands or sits in the hands of the trustees. They manage those assets based on the memorandum of wishes, which is effectively the wish list or the objective or the plan that was put in place when the trust was established. So that might be for the trust to be held during the lifetime of the child and then ultimately be paid to the grandchildren when that child passes away, for example. So protection for the children, looking at protection from business failure, so that, yes, going back to Petrusevich or Hawkins, if there is a business risk, business failure, the assets are not held in the individual's name, therefore they are protected from business creditors or the official assignee or any other liquidation issues. And of course, excuse me, from the relationship point of view, the best time to look at setting up a trust is not when you're about to go over that 3-year mark with the partner or you're about to make some further commitment. It's prior to getting into a new relationship. The 3-year provision under the Property Relationship Act would say that if you've deprived yourself or transferred assets out of your name to protect them from a relationship, then that would be able to be challenged and potentially would be overturned in that. So it's about planning, it's about, as far as possible, crystal ball gazing and looking at potential issues and putting in place that protection. And at the end of the day, a trust is a form of insurance in that it is ensuring that those assets are protected and are held and looked after for those people that you want to benefit from them. I mentioned before about wills and the ability for wills to be challenged, whereas a trust cannot be challenged unless it was set up deliberately to avoid a claim from a business or relationship issue. However, with a will, there are 3 pieces of legislation which enable people to contest wills. As you can see there, these are the Property Relationship Act, Family Protection Act, and the Law Reform or Testamentary Promises Act. So wills are able to be challenged. Under the Property Relationship Act, as I mentioned before, there is a presumption of a 50-50 split of assets in the event of death or separation. So, for example, if an individual owned a property, it was in his name, he had owned it for 10 years prior to the relationship, he then passes away, or that relationship fails, then that surviving spouse can claim 50% of that asset. So was that the intention? Was that the objective that the deceased had, that he may have wanted that property to go to somebody else or to be used for some other purpose? The Family Protection Act, this provides the ability for a person to contest the will on the basis that the will maker had failed in their moral obligation to provide for them. So what does that mean? Clearly, in the event of a spouse situation, if, for example, under my will, I left my estate to the rugby club, clearly I am in breach of my obligation under the Family Protection Act to provide for my wife. However, if for reasons I had 4 children and I wanted to omit one of those children from my will, by doing that under the will, that child will be able to contest my will for the same provision as those other 3 children. However, if I had my assets in a trust and only had those 3 children and not all 4 children as beneficiaries, then that 4th child would have no right to contest my trust, because the essence of the trust is that those assets are owned by the trustees, they're not owned by the individual, therefore these pieces of legislation apply to the individual, not to the trust. And then the 3rd piece of legislation, the Testamentary or Law Reform Act, states that if you have made a promise to leave somebody something and don't fulfill that promise under the will, then they have the right to contest. So again, it's the ability for wills to be challenged, whereas for a trust, unless, as I mentioned previously, it was set up deliberately to avoid those business or relationship issues, then there's no grounds or circumstances for the trust to be challenged. So, David, do you want to take or organise the poll now?
Yes, so I mentioned at the beginning, actually, during these webinars, we typically run a poll or two just to, number one, make sure you're awake, and number two, just find out some information about the audience and what they do from an advice point of view. So the first poll we have today is estate planning a part of your advice process? And you've got 5 different answers. You can tick one or more in this particular poll. So if more than one apply to you, then feel free to tick it. So the question is estate planning a part of your advice process? Yes, I include questions on my fact find. Yes, my advice includes estate planning recommendations. Yes, my implementation process includes follow-up. That's in relation to estate planning. I provide some general guidance only, and no. So if you could tick that. We've only got, give it a few seconds. We've got 20, 28, 30%, 50% voted. See if we can get 80% on our voting. See how many of the audience are awake, actually. Hopefully most of them are.
I'll say there's a chocolate for all those people that participate.
Excellent. We'll mail it to them. Right. Okay. Give it 10 more seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Okay. Let's close the poll and let's share the results, Brian. That's encouraging. We've got 80% of the audience include questions in their fact find. 29% also include advice recommendations on estate planning. 31% include implementation process follow-up, which I think is really important. 71% give some general guidance only, and there are 6% that said no. So interesting.
Thank you very much. Okay, so I suppose really the question comes down to, it's not a question or a situation of everybody having to have a trust or needing a trust. I think personally, and from an industry's point of view, we need to put our hand up and say, yes, a lot of people that have gone into trusts either didn't understand, weren't properly advised, or it has been a transactional process whereby they've come along, the clients come along, they've said to us, we need a trust, we've completed the trust, and there hasn't been that proper process, that proper planning, the proper information gone through with the client. So there needs to be that awareness, that understanding, and I put there that it's a cost-benefit exercise. Yes, the monetary cost, and you're looking from a, depending on the nature and complexity of a trust and the assets going into the trust, anything from $3,000 up for the establishment of the trust. You've also got the psychological cost as well. That is the knowledge that as the individual, you no longer own that asset. It is no longer yours to do with as you see fit. The asset is held by that different owner called the trustee, and the trustee is wearing a different hat from you, the individual, and has different obligations, responsibilities, and liabilities. So from a cost point of view, that needs to be factored into the decision of going ahead with the trust versus that benefit. What is the desired outcome? What is the reason? What's the protection that is necessary? Is that risk that they are looking at covering, is it a real risk, i.e. are they concerned about relationships? Are they concerned about business failure? Are they aware that to achieve the protection there needs to be that cost, that loss of ownership, that loss of control? And also from a cost point of view, and going back to the question of the review of the Trust Act and what this will mean for trustees, is the greater need for process, for procedure, for documenting everything, and that will come at a monetary cost. So there will be greater costs to run a trust, in that there will be greater scrutiny, greater accountability, greater emphasis placed on process and procedure. That second point, we've talked about that loss of control, but the ownership, the transfer of title, the transfer of control to the trustees. I would suggest that 99% of clients that don't go ahead with trusts, that is the reason that they don't. They don't want to abdicate or to cut the ties from the asset and the control and their ability to do with those assets as they see fit. The formalities of dealing with trust assets, I mentioned just before about process, procedure. Yes, for a trust to be run properly, and I'll talk about this in a minute as well, there needs to be proper processes in place, proper procedure, documentation, meetings. It's not just a matter of meeting once a year over a Christmas lunch with a few too many wines and signing documents. And I say that somewhat tongue-in-cheek because unfortunately my sister, much as I love her to bits, falls into this category. She meets with her sister-in-law in Dunedin once a year over Christmas and signs all the trust documentations. That, with due respect, is a waste of time, a waste of efforts, and potentially exposing her to a risk, because all she's doing is rubber stamping what has been done, and she hasn't been involved in decisions about any change of assets, any transactions that have occurred during the year in that. The ability to distribute income or capital to beneficiaries. Often we get asked about what basis are decisions made as to whether income or capital should be paid, and should it be by way of a distribution or should it be rather by way of a loan? The classic example might be mum and dad wanting to help out the son or daughter. They've got funds in the trust, they're happy for those funds to be used by that son or by that daughter. So what we would suggest is that rather than making a capital distribution whereby the money goes from the trust to that child, that distribution or that payment is by way of a loan, and that loan is both to the son and his spouse, so that in the event of any sale of the property or breakdown of relationship or issue, then the trust calls up that debt and gets that money back. So there's the discretion or the ability to consider what is appropriate as far as distributions from the trust. So clearly, when you're looking at establishing the trust, why do you want the trust? Is it just because over the barbecue you felt like you're an outcast because everybody was talking about a trust and you didn't have one? No, it's not. It's about what are your reasons, what are your risks, what are you trying to achieve? Is it something that is really necessary, or is it something that you perceive? What is the real benefit to you in the trust? What is the risk that you have? Then you'd need to look at what assets go into the trust. Is it the family home? And I haven't got statistically correct figures, but I would suggest that 80 to 90% of trusts that are set up in New Zealand own as their only or major asset the family home. So predominantly people are looking at putting the family home in the trust to protect that. But having said that, other assets are appropriate, and especially life insurance, for example. The life insurance policy can be issued and then transferred into the names of the trustees and held to provide that cash or to provide that benefit that the life assured initially wanted, or the reason or objective for setting up the policy was. So that provides the cash that goes into the trust that it then achieves that protection or benefit for those individuals that the life insured had wanted to protect or provide for.
That's an interesting comment, Brian. In fact, it answers a question that Linda Taylor has raised. It says, I was advised the trust cannot own a life policy. Trustees own a life policy as individuals and need backup documentation to ensure the funds go into the trust. I'm not entirely sure that's 100% correct. I think the trustees do own it as individuals, but as trustees rather than individuals. Am I right in thinking that?
Yeah, that's right. So if, for example, David and I were trustees of the Smith Family Trust and a life insurance policy was transferred or wished to be transferred to the Smith Family Trust, then the ownership would be recorded as Brian Iverme and David Yates as trustees of the Smith Family Trust.
Right. So it's that capacity as trustees rather than necessarily their capacity as individuals.
Yes, that's correct.
Yeah.
Yes.
Okay. Thank you. And I'm all right also in thinking that when you set up a life insurance policy, you it has to be set up with an owner different to the trustees initially and then assigned. Is that correct? Or can it be done?
That yes,
Sorry.
yes, the trustees cannot be the proponent of the life insurance policy. So the individual would take out the insurance, have the policy issued, and that would then be transferred into the trust.
Brilliant. Thank you.
Cool. Okay, so once you've decided you need a trust, what you want to put into the trust, then who you want to benefit, and as I mentioned previously, you can be discriminatory in electing who your beneficiaries of your trust will be. So you can exclude children if there was a particular reason for it, or you could have a trust for a specific purpose for a specific child only and not have other children. So there's that, unlike the will where there's that overarching legislation which could enable people to challenge if they felt that the moral obligation owed to them wasn't carried out. A trust, you can be discriminatory or prejudicial in who you have as beneficiaries of your trust. You then need to look at who the trustees will be, and I'll cover this off shortly, the roles, responsibilities and obligations of trustees. So once you've decided who the trustees will be, the terms. At the moment, a trust can run for 80 years. The proposal under the review is that a trust will be able to run for 150 years, which is the English basis or the English model at the moment. At present, under the Perpetuities Act, a trust in New Zealand, unless it's a charitable trust, cannot run for more than 80 years, whereas the change or the proposed change will be that it will be 150 years. And then lastly, a name for the trust. Okay, and in light of time, I won't go into too much details, but as far as the establishment process, once a proper needs analysis has been completed and a plan prepared, then the trust deed and supporting documents are prepared. And these will be based on what assets it's proposed to go into the trust. So with the abolishment of gift duty, you are now able to transfer the full value of an asset into a trust immediately. So for example, you've got a property or a client's got a property that's worth $1 million, that can be fully gifted at the time that the trust was established and the assets transferred. The fishhook or red flag, if you like, there is that if you do that and you, for example, are a director of a company, there may be an insolvency question regarding you as a director, because directors have to be solvent, and if you transfer all your assets and you no longer have them, technically you are insolvent or you could be insolvent. So there needs to be careful consideration of the sale versus gifting transfer, or the sale versus gifting process and treatment of the value of the asset being transferred into the trust. As far as documentation, as I mentioned before, when the titles for a house, for example, are transferred, it needs to be recorded correctly. Also, again, going back to life insurance, that the transfer is documented, that there is that memorandum of transfer changing the ownership from the individual's name to the trustee's name. That last point, the difference between the outright gifting or leaving a debt back to the trustees. So, for example, if there was a $500,000 investment portfolio that was being transferred into the trust, the two options could be to gift the full value straight away and therefore not have any clawback or entitlement to that. Alternatively, there could be a portion of it, say 250,000 gifted, and the remaining 250 lent to the trust. What that then means is that the individual could call up that debt or say to the trustees, you owe me $250,000, I want $50,000. They are then calling up that debt and would get that payment back as of right. Whereas if the money was fully gifted and there was a need by the individual to get funds out of the trust, the trustees would then have to make a decision to make a payment and would have to consider all of the beneficiaries and go through that whole process and procedure. Whereas if it's a debt still owed, the individual calls up that debt, it's paid back straight away. So it's case specific as to what is appropriate. A lot of people think they just should gift all of the amount straight away and get it over and done with. That's not necessarily the correct answer or the correct way. It's very much based on the situation they're in and what's best for them going forward and any potential need that they may have to get funds or to get assets out of the trust. Okay, if we look at the trustee's duties, and again coming back to the proposed change of legislation, these will be strengthened and will become more vigorous. But at the moment, clearly trustees must read and understand the trust deed. So they must know what they're dealing with, they must know what they can do, they must know what they can't do, what powers they have, what powers they don't have. They have to exercise prudence, diligence, skill and due care. This is the prudent person legislation or the amendment to the Trustee Act, whereby trustees have to act as if those funds were themselves, as if they were their own funds and what a prudent person would do. So it's not just blindly going off and doing something because they thought it was a good idea, or not just blindly signing something that's put in front of them by their co-trustee because that other trustee thinks this is an appropriate venture to enter into in that. They must act fairly and impartially. So they can't be seen to be favouring one beneficiary over the other. Again, going back to the comment I made before about when trustees make a decision to allocate funds to a beneficiary, they have to look at all of the beneficiaries and not just the one beneficiary who's asked for funds. Look at the circumstances, look at the situation, consider all the beneficiaries and what their needs might be, and then make a decision to pay. And it might be just to pay to one beneficiary and not all of the beneficiaries. From an investment point of view, yes, they have to invest prudently and invest based on the risk profile of the trust, not the individual. A lot of trustees or a lot of investments are done based on the individual's portfolio, profile or risk, whereas the profile should be that of the trust, of the beneficiaries, because as I mentioned before, potentially a trust could run for 80 years. So is it prudent to be a conservative investor when potentially the trust could run for 80 years and it should be more capital growth or aggressive, obviously depending on circumstances and that. So it's important that the risk profile of the trust is considered when the funds are invested by the trustees. All trustees have to act unanimously. So all modern trust deeds have that clause in it, which means that if there are three trustees have to agree. It's not a 2-1 split, for example, in that. So there is that requirement for unanimity between all trustees. And trustees cannot delegate their duties unless it's stipulated in the trust deed. Often, and this is a good example of it from an investment point of view, the trustees cannot delegate their investment responsibilities, but they can delegate the investment planning or the investment recommendation to an expert, i.e. a financial planner or an investment advisor. So the advisors give advice, but the trustees make the decision as to the actual investment. So they make that decision, they make that investment based on the recommendation and advice of their professional or appropriate advisor. Okay, as far as duties continuing, they cannot profit from appointment. And I'm not sure whether many of you would have seen the recent court case here in Auckland of the individual who was murdered in a motel in Epsom, and 2 young individuals were convicted of his murder. At the same time that that case was going on, the deceased unfortunately had not made a will. His brother was appointed as administrator of his estate. He had been acting in the management of that estate, but he had charged a fee of $9,500 for his services. He had no authority or no ability to do that, because unless it's stipulated or unless it's in the will or the trust deed, then there's no ability to profit from that appointment. It's a very interesting case, actually.
What does profit mean in that case, Brian? Can you not be, can a professional trustee not be appropriately remunerated for any work that they've done?
No, unless there is a clause in the deed that says that they are able to do that. So if, and in most deeds it says professionals can charge, but if you or I, as Joe citizen off the street, for want of a term, were acting as trustees and we wanted to charge a fee for our time and attendance, then no, we wouldn't be deemed to be professional, we wouldn't be covered under that clause, so we wouldn't be able to charge for our services, no.
Right, okay, thank you.
Mm-hmm. Clearly, trustees have to avoid conflict of interest. So if there's a company that's shareholders are both the trust and the settlor, then there's potentially a conflict of interest. But what we would do, and certainly what most trusts contain, is the ability for there to be the option for an individual, if he has shares, then, for example, those shares could be held by the trust, and as long as those shares were being managed properly, he was a director of the company, he was also a trustee of the trust. Whilst potentially there's a conflict, as long as the trustee authorised that relationship, then that would be okay. I mentioned before about taking into account circumstances of all beneficiaries and accepting that the trustees have to account and provide information to beneficiaries. And again, this is what the proposed new legislation will be putting in law to trustees, that they will be required to do this. Whereas a lot of trusts and trustees at the moment aren't providing that information. The classic situation is Dad set up a trust back in the 60s for his son, didn't want the daughters to know about it. Post this new legislation, that will be a requirement for trustees to provide accounts and documentation to all beneficiaries, so that the trustees will have to go out and say, hey David, by the way, you are a trustee of this trust, here is all the information relating to that. That is where the new legislation is going. And probably that last point, and probably most importantly, trustees can be held personally liable. So where trustees are challenged and it's shown, or for whatever reason there was a issue with their role as trustee and there's been a financial loss incurred, then there is the potential for that trustee or those trustees to be held personally liable. Okay, so clearly, would you be a trustee? Why would you be a trustee? Or how the heck do you get out of being a trustee? So it's important that when you look at a trustee, who is appropriate? Do they have the skill, the knowledge, the competency to be a trustee? How complex or detailed will the trust be? What are the trustees going to do? Do they want to or know what they will be letting themselves in for? Are they capable? Do they want to potentially be stuck in the middle of family feuds disputes, arguments? Can they act objectively? The second poll now.
I'm in the interest of time, Brian. I think we'll just move straight on because we've
Okay,
got about
carry on.
5 minutes to go. Yep, yep.
I was going to say, as per usual, Brian's carries on talking. Yes, sorry, David. So if we look at challenges to the trusts, where are the challenges coming from? Yes, the sham trust situation. The courts are looking at trusts, and a sham trust, what we mean by sham, where there was no intention to set up the trust, where the assets have been transferred and for all intents and purposes are still being managed or controlled by that individual, where there is the intention to retain control, direction, or treat those assets as if they were still the individuals. So why or how do we avoid the sham situation? And again, this is where the legislation is coming from, and this is where a lot of trusts are being reviewed by the settlors and trustees at the moment to make sure that there are proper minutes, resolutions, that decisions, for example, when a purchase of a property is being made by the trustees, why was it that a new property was being purchased? What basis was it purchased on? How was the value agreed at? What decisions, what resolutions were made to record that transaction? Where there are more than one trustee, have all trustees been involved in that decision-making process? Have those decisions been recorded? And the minimum of annual meeting, review of the investments of those assets. And I would also suggest the insurances. Have the insurances, both from a fire and general point of view and from a life point of view, on assets or that are part of a trust, have they been reviewed? Well, we mentioned before about the Property Relationship Act and the challenges potentially available through a trust from that. So was the trust set up more than 3 years prior to the relationship commencing, or was it set up 2 years into that relationship? One of the most topical points at the moment is the residential care situation, and MSD have effectively said if you've got a trust, you'll be, I shouldn't say out of luck, you'll be highly unlikely to get any form of assistance from a residential care subsidy perspective in that. One of the first questions that they are asking on their MSD application is, do you have a trust? Are you a settler of a trust or a beneficiary of a trust? We've mentioned before, I mentioned before the Clayton case. I'll just quickly go over this, and I'm, sorry David, aware of time. So in this situation, the Supreme Court has ruled that the trust itself was not a sham. The power to appoint and remove beneficiaries didn't in itself constitute property under the Property Relationship Act. However, the court held that that power, combined with other personal powers under the trust deed, could amount to relationship property, as the holder of all such powers is not constrained by any fiduciary duty when exercising the powers. So what does that mean? Mr. Clayton had the power under the trust deed when it was established that he was able to appoint and remove beneficiaries, he was able to alter, he had that protector power. So that power was vested in him as an individual. So when we say was not constrained by any fiduciary duty, that's the duty of a trustee. So that was his personal power, and the court found that the value of that power that Mr. Clayton held in relation to the trust was equal to the value of the net assets. So by having that power, by having that ability, that in itself equated to personal property, which then came into his hand, which was then made it relationship property, and that effectively was the basis that the court said that should be treated as a personal asset, therefore there would be a presumption of a 50-50 split of assets. it's interesting to note that this verdict and there was a settlement prior to the verdict, but because of the groundbreaking or the precedent-setting basis of this, the court actually gave its verdict, even though the parties settled prior to that coming out. So the message...
Go ahead, Brian.
Sorry, David. Okay. So the message, or what is the effect of this, is that for a trust to be effective, there needs to be that clear delineation and transfer of powers from the individual, so that the individual has to accept that to have the protection, to have that benefit, there needs to be that loss of control. The other important thing that came out through the courts that they have ruled is that the Section 21 or contracting out agreements, potentially that needs to be current, it needs to be reviewed, and that needs to be done at the same time that a trust is either set or you're looking at setting up the trust.
Just an interesting case, that one in particular. I mean, there's a lot of people saying, "Oh, that sort of suggests that in fact a lot of trusts would no longer be relevant," and then the fact that the name Clayton is quite appropriate, isn't it? The interesting thing that you raised there, though, is that there are some subtleties in relation to that case that made it a sham. It wasn't the fact that the trust itself was a sham.
No, that's right, exactly. Yeah. I'll just actually, quickly find, sorry, I'll just looking at the actual ruling here and what the court said. Yeah, a poorly administered or reprehensible trust is not a sham. So it's it's not that it wasn't being run properly or that it wasn't being administered. It's about the ability for that individual to exert that control or to have the powers to do things, i.e. to remove people, to include people, to have the control over what is happening. And that was the essence of the ruling for Clayton. Yeah.
Thanks, Brian.
Now, from a time frame point of view, David, I'm appreciating that I've gone over time as per as my normal. I'll just quickly talk about the financial advice implications for insurance policies, especially. Look at transferring ownership. Look at payments of premiums on insurance policies. If, for example, I set up a trust, I transfer my policy into that trust, I continue to pay by way of direct debit out of my personal bank account the premium on that policy. Effectively, it's a waste of time my having transferred that policy into the trust unless I record by way of annual gift the payment of that premium. Because if I'm paying the premium, I have effectively got ownership of that, and there have been numerous cases where the official assignee has challenged and said that policy has been paid by the individual, that policy is his, we will recall or make a claim against the trust for the proceeds of that policy. So payment of premiums is critical, and the documentation and recording of those from the trustee's perspective. But also from an advisor's point of view, if you know you've got clients that have got trusts, policies, have they or are they recording those properly through the trust, either by way of gift or additional loans to the trust? And then lastly, with respect to mortgages and lending, make sure that there is a awareness of the differentiation between loan and mortgage, and whether the loan should be in the trust or in the individual's name. In the majority of cases, it should be that the loan is held by the individual but secured by way of mortgage over the trust assets in that. Okay, David, I'll wind up there then. If there are any questions, comments, or thoughts, happy.
There are a whole ton of questions. This is a really fascinating topic, Brian, and it's very, very relevant to our audience. So appreciate you're trying to cover off an enormous amount of information in a relatively short space of time. And in the interest of time, what I will do is rather than run through, as I say, there's a lot of questions come up. rather than run through all the questions now. What I'll do is I will raise the questions with you if I can through perhaps email, Brian, and we will, when we post the video up onto our blog, we will include the questions and the answers to those questions on that post. So we'll get that through hopefully to the audience early next week. So if you've got any other further questions you'd like me to raise with Brian, please do so by sending me an email. I hope today's session has been of value. I know it's, as I say, it's an area of particular interest, and I think it's of enormous relevance to every single financial advisor, because it has, from an asset protection, from a advice point of view, it's really, really important that these things are factored into the advice recommendations, the advice thinking. So Brian, thank you again for your time today. Thank you for putting that together. We will have, as I say, this is the first of a series this year. We're running another two, which are running later in the year. So we keep an eye on your email. We will let you know specifically those dates. They are scheduled, but and the details are still being worked through. But I hope you found it valuable. Feedback, as always, please, positive, negative, any things that you think we could be doing better. And if you, as I say, if you wanted to take advantage of the structured CPD, please make sure you complete the last two questions of the survey, which will appear when this webinar finishes. And you'll also get a second opportunity in about an hour's time when the email comes through. Have a great weekend, everybody, and we will see you online at our next webinar. Brian, thanks very much for your time.
Thank you, David, and thanks everybody for the participation. Much appreciated.